with us Professor Dr. Anurag Deep Sir, Professor at Indian Law Institute, New Delhi. And Sir is going to speak about the challenges of comparative research in law. And before we begin this session, I would like to introduce Professor Dr. Anurag Deep Sir, who also happens to be my teacher, my guru, my supervisor. And to sum it up in one line, whatever I know today, wherever I am today, and whatever I've achieved in life today is all because of Professor Dr. Anurag Deep Sir. So thank you so much, Sir. To introduce Sir, Sir has more than 22 years of teaching experience, and Sir started the case-based method of teaching in Gorak University. Sir has over 50 publications in English as well as in Hindi in various reputed journals and books. Sir is also in the editorial teams of journals like ILI Law Review, which is a UGC recognized journal, and Campus Law Journal, which is probably amongst very few journals which is a bilingual law journal in India currently. Sir's core area of interest is criminal law, constitutional law, and human rights law. And Sir has authored 2 books, one on law of sedition in India in 2018 and one on bail in 2019. Sir was also invited by the Criminal Law Reforms Committee constituted by the Government of India in 2020 and was invited by the Law Commission of India for consultation on sedition. And his book on sedition was relied upon by the Law Commission of India in its 279th report on sedition in 2023. Sir's research work has also been recognized as a resource material by Max Planck Institute of Germany, and Sir has conducted various workshops on research, and Sir also conducted one international workshop on research writing with University of Portsmouth, United Kingdom. I welcome you, Sir, and I thank you for accepting our invitation to address the first batch of PhD scholars at NLU Goa. Sir, again, it's an honor to have you with us and to moderate your session. It has been a wonderful journey throughout with you, and I only wish to continue my association with you and hope to learn more from you in the upcoming times. Thank you so much, sir.
Thank you for such a generous introduction. As I often say, two lines. I cannot resist telling you ही कहो कहते रहो अच्छा लगता है. So we all love praise, and so am I with all my human weakness. It is always a pleasure, an enriching experience to interact with young brains. It helps me in many ways. Once Ramjet Malani was asked, what keeps you moving and why are you being chased by everyone? One thing he said, that I am in the company of young people. So I'm trying to take some clue from Ramjet Malani, though I know that to reach to his status is almost a dream for me. So a very good evening to everyone. Before I begin, there are certain rules of the games. And the first rule of game is that it is not a lecture. It is an interaction. Pass it. It is not a lecture, sorry. It is an interaction. हम जब किसी ट्रेन की कोच में बैठते हैं, हम बातचीत शुरू कर देते हैं. फ्लाइट में तो नहीं पॉसिबल हो पाता, क्योंकि आधे घंटे में हम निकल जाते हैं. बहुत बिजी लोग भी होते हैं फ्लाइट वाले. लेकिन ट्रेन में आपको सफ़र करना, तो ये इसमें इंटरेक्शन है ये. And therefore I have asked ki, is it possible that you can also give your opinion in between without, you need not worry, because I have a PPT, you need not worry whether I will be disturbed. I won't be disturbed. I must have delivered on FDP in this PhD coursework. I must have delivered around 25-30 lectures. Many of them are uploaded on my YouTube channel. On comparative law, this would be my third or fourth lecture. One is already uploaded. We'll try to upload this one also. So need not worry whether I will be disturbed. I won't be disturbed. I love disturbance. And I love questions. And the most important thing that I love is disagreement. Dissent. So I hope you will not disappoint me and you will disagree with me. Just raise your hand. So, yes, thank you. Just raise your hand that you will disagree with me. And whenever it comes to your mind, immediately just raise your hand, either virtually or so that I can stop and I can discuss. Now, the title is the challenges of comparative research in law. So I will begin with, I will discuss the PPT, but I will first begin with law word. And we are not going to discuss what law is. We know that jurisprudence, volumes and volumes have been written, and there are a number of disagreement on what law is. So I am not going to plunge in the field which is very controversial. But for the purpose of researcher, what is law? For the purpose of researcher, what is law? And the idea that I have developed in various classes, various programs is that for the purpose of researcher, a law contains the element of P6. P6. P1 is principles of law. P2 is, can anyone guess? P6 है तो एक दो तो गेस कर ही सकते हैं आप. All begins with P. ये आपको मैंने एक पहला क्या दिया है, उसको एक हिंट दिया है. फर्स्ट इज प्रिंसिपल्स ऑफ लॉ. क्या है मैं डिस्कस करूंगा. बट व्हाट आर अदर पीज? वेरी सिंपल, आप सब जानते हैं इसको. यू ऑल नो. सो देयर इज नथिंग बैड इन गेसिंग इवन इफ इट इज रॉन्ग गेस. कोई बताइए. हाँ हाँ बताइए, कौन बताना चाहते हैं?
Practice of law.
Practices of law. Good. So
That
these
is
practices,
postulate.
one by one. Practices of law is P6. Practices of law is P6. आपने बता दिया. चलिए और बताइए. Postulates, शिवानी बोल रही है postulates of law. ठीक है, postulates तो I am keeping these postulates in principles itself. So jural postulates. Postulates I am keeping it in the principles. ठीक है. But you can make difference. If you can make difference, I am convinced. Next time I will acknowledge you and say now P7. अच्छा P2 तो हो गया. बताइए तीसरा क्या है? P. हाँ,
Sir, process of law.
प्रोसेस ऑफ लॉ. ओके ठीक है. चलिए और कुछ मोर कॉन्क्रीट. ठीक है. हाँ बताइए.
Philosophy of law.
Philosophy of law coming in principles. Philosophy of law is coming in principles. Unless you make a very, very strong distinction that sir, philosophy and principles are two different things. They are apple and orange. You can make it. चलिए और progress of law. Okay, progress of law. Okay, ठीक है.
Planning of law, sir.
What is of law?
Planning.
Planning of law. Okay, ठीक है. Planning तो है, word दूसरा है, लेकिन planning of law है. Very good. I am finding a lot of words. You can see people. You can think of. कितने सारे words? हाँ?
Precedence.
Yes. Professor Venugopal. Precedence. So precedent is another P for me. So now let me solve this riddle. So P1 is principles of law. P2 is provisions of law. Black and white. Which article, which section, which schedule. Third is policy of law. Now some of you can tell me the difference between first and three, P1 and P3. Then fourth is precedent. आप में से बताया किसी ने अभी, बहुत अच्छा, वेणुगोपाल जी ने बताया. Fifth is professional opinion. So what is the opinion of Law Commission of India? What is the opinion of Professor Dicey, Bodenheimer, Narad Smriti, Panini, Justice Kadju, Justice Chandrachud? What is the opinion of? So, expert opinion, professional opinion. Your opinion is also a professional opinion. Big or small hardly matters. And finally, पांचवा तो अपने शाश्वत सुराज ने बताया ही है. क्या बताया है? Practices of law. For researcher, all P6 is important. All P6. And indeed, it is one of the tests of a good research work. Do you contain all P6 or not? One of the. I'm not dilating on that because my topic is a different topic. Now I come to another significant word, and that is I think this PPT is visible now.
Yes, sir, it is.
So key drivers for research. So second significant point is research. What is comparative research? What are do's and don'ts, and the concluding remarks. Now first, when you talk about research, I think a lot of people must have told you about this. But just to refresh our memory, Savio JF Korea, sorry for if it is a bad pronunciation. You want to say something? Yes, no problem. You want to say something then.
Sorry, sir. That
that was regarding philosophy.
Hands up remained on. Sorry.
Okay. No, this is a very crucial point, gentle persons, because probably 80 to 90% of the researchers, young researchers, do not make difference between research and steps of research, and they mix it, and they think they have done great work, but their articles are not accepted by good publishers. They do not know why, because unlike the Journal of ILA Law Review, which was just now 1 month, 2 months back, was headed in the able leadership of Assistant Professor Goa Niveta Chaudhary, Dr. Niveta Chaudhary, where we try to give answer, address, reply to everyone. Many journals do not respond, they only reject. Why? You keep on thinking, oh क्या बात है, क्या कमी रह गई मेरे में. Sometimes you think, okay, केवल उनका छपता है जिनकी कोई सोर्स पैरवी होती है. Because there is no answer. आपके पास आंसर नहीं तो क्या करेंगे आप? One of the problem is because the researchers, the PhD scholars, the writers mix the steps of research and with research, and they only follow steps of research and think that now the research is complete. So let us understand what are steps of research. You collect material. You have decided a topic and then you collect material. Or not decided a topic, you are going to decide the topic, you collect a material. You organize the material. That also takes time. You read various material. to found whether it is relevant or not relevant. That is very difficult job, time-taking job. You write something, and after writing you think, oh my God, I have done great job. I have maybe for more than 1, 2, 3 months I have spent 3, 4 hours, 5 hours every day, gone in the library, and ultimately I have collected material, organized it, read it properly, written something and concluding remarks, and then some footnoting, and my article is not published. Why? Because they are steps of research, they are not research themselves for the purpose of law. So you would be surprising, then what is research? If it is not, it is of course steps of research. And very, very difficult steps. These steps are very difficult, but ultimately they are not research. Why? Because many of us do not make analysis of the provisions. We place the provision, we do not make analysis. Or if we make analysis, it is casual type of analysis. It seems type of no mind is applied. I'm not going in because that is not my topic, how to do analysis. That is a different topic. Suppose we have made analysis, then we do not go into the strength and weaknesses of the provision. I'm generally provision, I do mean P6, all P6. So you use one P, whether you have made analysis of that, you have broken it, and whether you have discussed the strength and weaknesses also, both, not just strength or not just weaknesses. And then based on these strengths and weaknesses, what are your views? You may follow something which is already said, or you may take a different view. And your view depends on certain rationale. If your view is a new view, it becomes an original contribution. If your view becomes a view which is taken by someone else, no problem. It still can be original contribution if you have a different rationale. But if it is the same rationale, your conclusion is not an original contribution. And if there is no original contribution for the purpose of law, for the purpose of maybe publications, probably this is not the research work that people are looking for. So to summarize, that we should know the difference between research and the steps of research, and let us not mix research with steps of research. Those steps of research are extremely time-taking process, but research means you should give some original contribution. What is the original contribution? I have given you some detail, but I am not going in that. I will try to show you what it can be. But if it is there, then I think one journal or other journal, or definitely the journal of Nivedita, will accept the idea. Maybe it may take some time, but we will accept the idea. So this I wanted to discuss with you, what is the meaning of research, because many times we mix these things. Now I come to the next important word, that is comparative. Now if you have a question, do ask me, otherwise I am skipping. Do ask me. Now comparative is not a term which needs some space science to understand. Every day we make it, consciously, unconsciously we make comparison. Every day. But why comparison? If we make comparison, should we institutionalize it? The answer is yes. Is comparative study an essential part of any research work? For me, of course, yes. It always gives you an edge over others. Some comparative work, especially at PG level. Indeed, one of my teacher, Professor Zariwala, used to say that this is the difference between UG and PG. In UG, you do not essentially make a comparative study, but in postgraduate, you do comparative study, and Professor Zariwala used to suggest us. He's a professor currently. He was a professor in BHU, and currently he's a professor in Ramandra Lohiya National Law University. He used to say, you start with comparative study. Want to write Article 21? Write what is the position in USA, maybe UK, maybe in other countries, anything. So comparative for the PG is almost essential. Now, why comparative? There can be 5 reasons, which I have mentioned, C5. It can be a compulsion of legal system. So we have a common law system. So we have common law system. So we have now America, Australia, Canada, all common law countries. So this comparison is natural. It is a type of compulsion for us also. Because we follow the same law legal system. Civil law system and common law system, 2 systems are there. This is one reason, first reason. Second is convenience. With the help of comparative study, it is easy to interpret fact and law. Many times it is difficult to interpret fact and law, but we make comparison, we interpret fact and law. And you will remember, do you remember any rule of interpretation which relies on comparison? Anyone from this learned gathering? Do you remember, आपको ध्यान आता है कोई ऐसा इंटरप्रिटेशन का रूल जो बताता है कि कंपैरिजन करना ही चाहिए, तभी कंपैरिजन से ही सही इंटरप्रिटेशन हो सकता है? You all know this, let me tell you. आप में से सबको पता है, हार्मोनियस कंस्ट्रक्शन, आई एम अफ्रेड नो शिवानी, बट वेल ट्राइड, वेरी गुड. और बताइए, कंपैरिजन ही करते हैं उसमें, और कुछ से दूसरा काम नहीं करते. हार्मोनियस कंस्ट्रक्शन कर सकते हैं, ठीक है, पर देयर इज ए बेटर आंसर आई वांट टू से. बताइए, थोड़ा ट्राई करिए, आप याद कर लीजिए जो इंटरप्रिटेशन में क्या क्या रूल्स हम यूज करते हैं, एंड यू कैन फाइंड द आंसर. मैं बताऊंगा, बोलेंगे अरे ये तो यस ये तो मैं जानता था या जानती थी. कोई बात नहीं, आई विल नॉट डिस्क्लोज नाउ, यू वेट फॉर द स्लाइड्स, और बीच में याद आ जाए तो बताइएगा मुझे. थर्ड इज करेक्ट डिटर्मिनेशन. व्हाट इज द पर्पस ऑफ मे बी जुडिशियल प्रोसेस? टू रीच टू द फैक्ट. व्हाट इज द करेक्ट पोजिशन? प्रेसिडेंस, ओके, नो, that can be, but not for me. No, again I would say golden rule. In comparison to golden rule, there is a better answer. I'm not telling, I'm not denying. Anyway, so correct determination, the comparative study helps us very much. You want to make correct, you make comparison, and many times you reach to the correct position. Cosmopolitan view. You want to decide something, but you want to know what is happening in other countries. And that helps you know, okay, US में ये हो रहा है, UK में ये हो रहा है. Cosmopolitan view, and you try to get the good practices. So comparative study helps us know what is happening outside the world. And then competence development also. That also develop our competence. You see, from Rig Veda, you have seen Anubhadra Kratuyantu Vishwata. Indian culture is so vibrant. It says, let the noble thoughts come to us from all directions. कहीं से, पूरब से, पश्चिम से, उत्तर से, दक्षिण से, from any direction, if noble thoughts, not all thoughts, please remember. Western philosophy says all thoughts. No. Indian philosophy says noble thoughts. Thoughts are always qualified by noble. That is one distinction between Eastern jurisprudence and Western jurisprudence. Eastern jurisprudence says thoughts, but noble thoughts. Western jurisprudence says any thoughts, that is a matter of liberty. And what Mahatma Gandhi said, I do not want my house to be walled in all sides, on all sides, and my windows to be stuffed. बंद नहीं रहे हमारे दरवाजे खिड़कियां, हमें बंद नहीं करना है. I want the culture of all lands to be blown about my house as freely as possible. जो दूसरी कल्चर है, संस्कृति है हमारे हाउस में, वो उसकी धारा बहनी चाहिए, उसकी हवा, उसकी बयार बहनी चाहिए. But I refuse. See, this is the point. जो but है, this is a caution for all researchers. Caution for all researchers. Why comparative? First two sentences of Mahatma Gandhi says why comparative. The philosophy not coming from anyone else but from Mahatma Gandhi, the great father of nation. But I refuse to be blown off my feet by any of them. पर इतना नहीं करेंगे कि हमारे खुद की फीट, हमारे खुद के जो पैर है उखड़ने लगे. I refuse to live in other people's house as an interpoler, a beggar or a slave. ऐसा नहीं कर सकते किसी के घर में चले जाएं, वहाँ बेगर की तरह रहें, स्लेव्स की तरह रहें हम. ऐसा नहीं कर सकते हम. स्वागत तो है सबका, ठीक है. तो यंग इंडिया में 1921 को लिखा था उन्होंने. 103 साल हो गए, 103 साल पहले लिखा था उन्होंने. एक और स्टेटमेंट आप देख सकते हैं in order to understand the philosophy of comparative study. Nothing can be farther from my thought that we should become exclusive or erect barriers. No, हमें एक्सक्लूसिव नहीं बनना है, हमें बैरियर नहीं लगाना है कोई. बट आपको देखा होगा अनुभद्रा कृत्व यंतु विशुद्ध, ही इज टेलिंग द सेम थिंग फ्रॉम ऋग्वेदा. बट आई डू रेस्पेक्टफुली कंटेंट दैट an appreciation of other cultures can fitly follow, never proceed. They should follow, but they should fit. हमारी कंट्री में फिट होना चाहिए. बाहर का प्रोविजन है, बाहर के प्रिंसिपल्स हैं. इफ प्रेसिडेंट्स आउटसाइड कंट्री, दे मस्ट फिट. इज इट फिटिंग? ये हमको ध्यान रखना है. इन दिस इज द ग्रेट चैलेंज एंड प्रोबेबली फर्स्ट इंपॉर्टेंट चैलेंज. Whether the comparative philosophy, comparative principles, comparative law coming, is it fitting in our country or not? It is my firm opinion that no culture had treasures so rich as ours. Mahatma Gandhi said, 1921. हमारा कल्चर कितना रिच है, इस बारे में महात्मा गांधी is telling. We have not known it, he says. We have been made even to deprecate its study. He is suggesting that how the English and the earlier rulers have damaged and demolished our temples and our cultures and our language and our gurukuls, so that our treasure should go and we became colonial in nature. An academic grasp without practice behind it is like an emblemed corpse. So practice, you see, and practice word I have used, P6, yes. So this is Mahatma Gandhi. So philosophy of why and how we should do this comparative study, this philosophy you can elaborate. Now when we say that comparative study has to be done, there are certain examples, but I am not going in that. I shall just move to the next slide. I have discussed the foundational philosophy. I have discussed the desirability also. Now, what are the various types of this comparative jurisdiction, comparative philosophy, comparative method of research? Now, first is within jurisdiction, that we often forget. When we talk about कि comparison किया है हमने, तो अच्छा comparison का मतलब तो other jurisdiction से करना है. No, never. Comparison तो within jurisdiction भी कर सकते हैं हम. We can do within jurisdiction, and we do it. Why not within jurisdiction also? So first is within jurisdiction, and then it's beyond jurisdiction. But the normal sense is that when we talk about comparative practices of research, we always say, अच्छा अमेरिका में क्या हो रहा है, यूके में क्या हो रहा है, कनाडा में क्या हो रहा है, जर्मनी में. No, that is one way. That is one very correct way. But we need to do comparative research within jurisdiction also, and we'll give some examples also. Let me give you a latest illustration of comparative research and what are the do's and what are the don'ts of this comparative research. You must have heard about the Shibu Soren case, which was recently discussed in Supreme Court. शिबू सोरेन केस, कोई बताएंगे आप में से क्या हुआ उनके मामले में, अभी भी क्यों उनका, why he became the matter of headline today, means not today but 2-3 days 4 days back? Anyone? I'm sure सब लोग न्यूज़ भी देखते हैं, न्यूज़ चैनल भी देखते हैं, व्हाट्सएप पे भी आता है, न्यूज़पेपर भी पढ़ते हैं. शिबू सोरेन केस. एनीवन? कोई बहुत आसान है, कोई कठिन काम नहीं है. क्या है शिबू सोरेन केस? अभी का केस नहीं बताना है, बहुत ब्रीफ में 2 लाइन में कि क्यों अभी हाईलाइट हुआ है ये. हाँ, अजय त्यागी जी बताइए.
He did not appear before the ED and therefore he was summoned.
हाँ, प्रोफेसर वेणुगोपाल. अजय जी वेट कर लीजिए, अजय जी प्लीज वेट कर लीजिए. हाँ, प्रोफेसर वेणुगोपाल बताइए.
He did not appear before the ED a
He
number
did
of
not.
times.
First thing, he did not appear. Very good. Second point.
And therefore he was asked to, make it mandatory that he appears before the ED after 7th or 8th time.
Okay.
And he appeared before and he was arrested because after finding out that there was complete evidence for his involvement in the scam,
Okay.
he was arrested.
Okay. Good. ठीक है, बहुत बढ़िया. हाँ, अजय जी, you would like to add anything? कोई चीज जोड़ना चाहते हैं आप?
Ji, I think so. The only thing is that he took money for supporting or following the government.
Allegation. There is an allegation.
Allegation.
Yes,
right.
there is an
And
allegation.
I think it was proved,
हाँ.
and that led to the ED and other things.
No. It is. I doubt it is yet it is proved. But because we are very senior people on PhD, so we should say that it is not proved. Means proved in a court of law for the purpose of conviction, for proof word. We should say that. So there are allegations against. So Shibu Soren was the chief minister of Jharkhand state, and he was issued 10 summons. See,
Sir, you are talking Hemant Soren. Shibu
So
Soren
no, Hemant Soren. Yes. I'm sorry. Please.
Shibu Soren
It's
is
not
the
Shibu Soren.
TV
Hemant
Narasimha
Soren.
Soren.
I'm sorry. This is wrong. Not Shibu Soren. Hemant Soren.
Yeah.
So I think probably this was the reason you took long time. It was Hemant Soren. Hemant Soren was CM, and 2-3 days back, so he was issued 10 summons. ED has issued 10 summons, and the 10th summon he was arrested. Once a summon is issued, you can challenge the summon. Summon was not challenged, or if challenged, the court did not stay the summon. That means that is the rule of law. You have to follow it. Anyone has to follow. Now he came to the Supreme Court, and the Supreme Court said that okay, he was arrested, but go to the High Court. If there is something wrong, you want bail, immediate bail, go to the High Court. How is it relevant for the purpose of a comparative legal research purpose? How is it relevant for the purpose of comparative legal research? Can anyone just tell me how is it relevant for the purpose of okay, let me give you a guess. There was great criticism. Indeed, there was an argument that in Arnav Goswami case, he was immediately given relief. So Hmm. Can anyone compare that Arnav Goswami case? He was immediately given relief. Hemant Soren, it was said that you go to the High Court. Is it not discriminatory? Yes, please.
It can be researched on the basis of that the Supreme Court has the power to send the case back to High Court if a person has appealed under Article 32.
Very good, very good. But my point is, when Arnav Goswami was arrested, the court has heard him immediately and also given relief. In Hemant Soren case, the court said, no, go to the High Court. I will not even hear you. How a student of comparative law, you take this fact and make an inference? Can I make an inference? Oh, the court is inclined to Arnav Goswami. Court is Modi supporter. Because Arnav Goswami is a Modi supporter, court is also Modi supporter. I want to make this inference. These are the allegations laid by maybe some of the advocates, some of the experts also. The courts are working under great pressure. For the purpose of Arnav Goswami, there must be a pressure from the government, and therefore Arnav Goswami was immediately granted bail. Not only he was heard, but also granted bail. And Hemant Soren, because he belonged to the opposition party, the government must have placed much pressure on the Supreme Court not to hear the case and then send it back. Yes, Ajay ji, bataiye.
Sir, the provisions of law were different. One was for corruption and other was for probably freedom of speech.
Very good. So, before reaching to the conclusion, when we make a comparison, of course this comparison is essential. ठीक है? So, Ajay Pathak she says that that it is probably because the provisions are different. One is a case of corruption and other is a case of free speech. Okay, चलिए देवल पाठक साहब बताइए.
Sir, in one case he was called upon after giving multiple notices, whereas in the other case he was arrested immediately without any prior intimations or notices being issued to him. So the provisions of CRPC with regards to prior intimation to the accused were completely void.
So, if someone reaches to the conclusion, oh my God, देखिए, maybe someone who is not in the field of law can reach to this conclusion, which I am telling. Acha, the Supreme Court is working under the pressure of the government. It is not that Supreme Court cannot work. Maybe there is a pressure. Sometimes there can be. But a researcher has to know the facts, has to know the law, has to know the principles. That is P1. How do you know the principles? You go into the facts, whatever available facts are there, and then you make a comparison. So in Hemant Soren case, as Ajay ji and Pathak Sahab has given me two different facts. One is that in Hemant Soren case, it is a matter of corruption. Of course there is an allegation, but corruption allegation and free speech allegations are two different things. One is a matter of fundamental right. That he is in the media, he is media, right to media is a fundamental right in Article 19. Of course, he must have said something very bad about one civilized and political lady. That is wrong, completely wrong. But does it warrant arrest followed by bail also, or not bail? And second is that not 1, 2, 3, 4, 5, 10 summons were issued. So court said, if you do not respect law, why should I exercise my discretion in your favor? It is a discretionary power. If you want that I should exercise discretion in your favor, you must have given some respect to the law. You did not appear for a single time, even if when your summons, where you challenged the summons and the court said we are not going to stay, that means you had to honor the summon. These can be two reasons. So even then you can reach to the conclusion, but then you need to have a different type of reasoning. So this is one way that when we make comparison, we have to be careful, go into the facts and then reach to the conclusion. And even then you want to reach to the conclusion, that it seems these two differences are there, but ultimately both were the matters of personal liberty. So therefore the Supreme Court has committed a blunder. You can reach to the conclusion, but give both the facts so that you are aware of the fact, and then you can come to a conclusion based on your own reasoning. Now, for the purpose of within jurisdiction, there is an authority from 1584, Haddon's rule of interpretation, and I was looking for this interpretation rule that you suggested, golden rule and others. They are also relevant. I'm not telling they are not relevant, but this probably, what does it say? Haddon rule. See, what does it say? I'm not asking much question now because I will see what was the common law before making the act. Act के बनने के पहले common law क्या था? The rule itself say go for the comparison. It is a rule which says that make a comparison if you reach to a particular conclusion. What was the mischief and defect for which the common law did not provide? What remedy the Parliament hath resolved and appointed to cure the disease of the Commonwealth? And true reason of the remedy. So you make a comparison. What was the law? 25 साल 30 साल 40 साल पहले क्या law था, अभी क्या law है? You have to make comparison between the law within jurisdiction. Policy, maybe policy also. It is for the purpose of act itself, but we can make. So dear friends, rule of interpretation, Haddon's case, 1584, probably the first significant example of comparative study. That you have to make comparison in order to reach correct decision. Therefore, we always say, आपने ये काम किया है, have you made some comparison? And often say, नहीं, we have not made comparison. Why? Come up with some comparison. So if you are trying to find, discussing something on rape case, are you making a comparison with POXO? If you are not making, question will come in. Why not? If you are discussing something of law of sedition, then people may ask, have you discussed something from UAPA? Of course, sedition in IPC, but have you made some? And then, so these type of comparison, therefore within jurisdiction is essential, and it is a part of rule of interpretation way back in 1584, which we are still following in 2024. Now coming to the beyond jurisdiction comparison, that is the classical comparison that we make. That in our article we have to make comparison what is happening in other jurisdictions. And in India, the Supreme Court judges and the professional opinion, they make comparison especially from USA and also from UK. Now I want to make a comparison India and Germany. So first significant point is that comparison has to be made. This is first point. The second point is there has to be a reason why comparison with a particular country. You cannot just pick. It is not a type of toss. You cannot pick, अच्छा चलो जर्मनी से कर लेते हैं, चलो फ्रांस से कर लेते हैं. No. There has to be a reason, and you will be asked, why comparing these 3-4 countries? Why not others? And you should have some reason for it. We often make comparison from UK because we have inherited their cabinet system of government and we were ruled by them. And we often make comparison from USA. And why we make comparison from USA? कोई बताएगा आप में से? Can anyone tell me? It is again third or fourth question. That why we make comparison with USA, and any special reason for this? Very easy answer. बताइए. Yes, पाठक साहब बताइए.
Sir, usually on two grounds. One is that is the best example of a civil law society as opposed to a common law society. And second, because they are right now in controlling position in the world economy, being the world leaders, their laws are mostly what are replicated around by newer nations which are getting into.
Good. So two reasons. One, that because US in a dominant position. So let us know what is going on inside the USA. This is one reason. And what was the first reason you told, Pathakji?
Sir, the first reason being that they are the best example of a civil law society,
Civil law
as opposed to a common law society. We are a common law society, they are a civil law society.
It is often said that USA is a common law. USA comes under common law jurisdiction
For civil law.
because USA was also a colony of UK.
I agree, but then
Okay, no issues, ठीक है. कोई और? हाँ, शुभम शुक्ला जी बताइए.
So basically, we can see the comparison between USA and India. Like the first example can be like whatever features which we borrowed in our Indian Constitution, like many of the features like citizenship restriction, what you have quoted here, and fundamental rights are influenced from US Constitution, and it is a common law system like as we have in place, right? Precedents there also play an important role in formation of policies. So because precedent, so we can say that because it's a common law system, we have a similarity in that, and we have constitution primarily influenced from US Constitution.
Yes. So third reason. So third reason is that our constitution is very much influenced from this USA constitution. This is certainly a very good point. Very good. चलिए और कोई reason बताना चाहते हैं? कोई इसी में थोड़ा elaborate करना चाहते हैं? ओके चलिए कोई बात नहीं. सो शिवानी, हाँ शिवानी बोलना चाहते हैं. इफ यू कैन स्पीक, वी लव टू स्पीक, लव टू हियर यू. और अगर केवल लिखा है आपने तो ठीक है, कुछ एलाबोरेट करें. यस प्लीज शिवानी.
I would like to add that we are adopting new principles from USA like this public interest litigation, then door-to-door justice, like active judiciary, this thing, and
Okay.
This judicial review, principles of judicial review.
Principles of judicial, very good. So to add to the Shubham, that judicial review principle was already there through Marwari versus Medicine 1803, and we have adopted it in the constitution in the written form under Article 13, under Article 32, under 226, and various other articles. That is very good. And so this is another reason. So fourth or fifth reason, you can write down these reasons why USA is a preferred choice for all of us. And you can dilate on that. You can further dilate, and it can be developed as a very good paper. What's the reason? So USA, there are compelling reasons why USA should be a comparative jurisdiction for destination for researchers. That is good. That is very good. So, but then, as Mahatma Gandhi said, you remember the but, that we have to be little careful, and that the researchers are not doing. That the first part they are doing, that they are taking things, not the researchers, the Supreme Court itself committed blunders and blunders and blunders in many cases. I will cite you one case. And imported the USA jurisprudence as it is, without thinking whether it is fit or not. And you will remember, just for our own sake, let us go back. See, I refuse to live in other people's house as an interpoler, a beggar or a slave. But I refuse to be blown off my feet by any. The Supreme Court in some of the judgments have forgot and was just carried away. So we need to be very careful, and that is the do's and don'ts that we need to understand. And I will just cite you 2-3 examples, dear friends. That USA is a preferred jurisdiction for researchers because of constitutional provisions. Of course, USA is a federal country and we are a federal country. We may differ in the aspect of federalism, but of course there is the distribution of power, and we have a distribution of power. And just a warning to everyone, that separation of power is entirely different from the distribution of power. Let us not confuse the distribution of power. So this is one reason. And second reason is that we have taken various provisions that you have rightly mentioned, but I will stick to fundamental rights, because in many fundamental right cases the Supreme Court and sometimes the researchers also have taken from USA. So that is certainly a good thing. We look into USA, that because the fundamental rights in USA was incorporated in 1791 through Bill of Rights, 1791. But then are we aware of the differences? And do we care for the differences? Both the things are. Number one, are we aware? And if we are aware, do we care for the differences? So let us begin with what are the differences. And I must have asked you what are the differences, but because I have just maybe 28 minutes more, I have many things to discuss with you. The first difference is that the fundamental rights, especially the freedom of speech and expression, is available to everyone, whether citizen or not citizen, in the USA, even to foreigners. But in our country, fundamental right to free speech is available to citizens only, not to everyone. Article 14 is available to foreigner. Article 21 is available to foreigner. Article 19 is not available to foreigner. Our framers of the Constitution, the great forefathers, were very much aware, but they especially choose the word citizen. Why? Because they never wanted a liberal interpretation of Article 19. What is the second difference? Restriction. If you read article, maybe amendment, first amendment to 10 amendment, or up to 27 amendment, these. Now there are 27 amendment. You try to find where are the restrictions on fundamental rights in USA. You will find none written restriction in the Constitution. There is not a single line on the restriction on fundamental rights in USA. Of course, the courts have developed certain doctrines to make restrictions, to place restrictions. But in our country, restrictions are placed in the Constitution itself. Not one restriction, not two restrictions. Take example of fundamental right. There are how many restrictions of fundamental right? Article 19, 1A only 8 restrictions. Not 1, 2, 3, 4. USA has no restriction, 0 restriction in the Constitution expressly. But in India, our forefathers placed restrictions. Our parliament increased restrictions in First Amendment 1951. Our parliament increased restriction through 16th Amendment 1963. We are a country where fundamental rights are restricted. Come to the emergency provision. Can we think of suspending fundamental rights, almost all fundamental rights in the USA during emergency, during war? No. There are one small exception. But in the original Constitution, up to 1978, all fundamental rights could be suspended. Indeed, they were suspended during emergency. See how restricted our fundamental rights are if you compare with the USA. It can be good, it can be bad, that is a different matter. But when we are comparing, are we aware and do we care these differences? And take example from 44th Amendment 1978. Two fundamental rights cannot be suspended now, Article 20 and 21, but rest of the fundamental rights can be suspended. Indeed, Article 19 automatically gets suspended during emergency. We cannot think of this in USA. What is the message? What is the message when we go for the comparative study? The message is that USA is a good constitution, it's a great constitution, we should learn from it. But when you import, do care what type of model USA has and what type of model India has. And therefore I can say that the USA has a model which can be said to be rights-based model. Rights are there, rights are prominent. It is the near absolute model, if not absolute, near absolute model. because Constitution at least does not talk about any restriction even till date. Of course, the Supreme Court has placed certain restrictions. In India, because there are restrictions under Article 19, restriction under Article 25, Article 26, express restriction. And therefore, our model is not a rights model. Our model is, which I often say, ROR, rights with RWR, rights with restriction model. So USA model, especially the free speech case, religion case, religious freedom case, we say it is rights based model USA, but in India it is RWR, rights with restriction model. When we make a comparison, we should be very careful, but the Supreme Court has not seen this. Take example of Shreya Singhal case. In Shreya Singhal case, Section 66 capital A was declared unconstitutional for want of Article 19, but not for the want of 14, not 19. I am not telling the judgment is wrong, but I am telling that the reasoning by Justice Nariman, that the US model is almost similar to, of course he does not say similar, he uses very cautious word, but the meaning comes something like as if US doctrine can be used in India. And he has developed 3 principles of human rights based on the US model. And he committed great mistake and liberalized the Indian model, which was not warranted at all, because the framers of the constitution never wanted it, nor it is warranted now because of the various situations. Why, when the model was already available with the framers of the constitution led by the great Bharat Ratna Dr. Ambedkar Sahab, he did not, why did he incorporate these restrictions? This was discussed in the Constituent Assembly. In the Constituent Assembly, they were very disappointed. Some of the members were very disappointed. And they said, oh my God, what you have done, Dr. Ambedkar and your team? You have given us rights from one hand and taken rights from the next hand by restriction. Dr. Ambedkar said, we have learned lessons from USA. Everybody should learn lesson from USA. He has used comparative way of research for the betterment of country. Let the noble thought come, not the thought which is a damaging thought. Because of the liberal theory that USA has followed, a lot of problem has been created in USA. Take example of fundamental right to bear arms. You know, in USA, bearing arms, having an arms is a fundamental right. You can go and purchase arms the way you go and purchase your vehicle. You just need some license. So you have a driving license, you can have maybe 2-3 cars. Similarly, if you have some license, you can go and purchase any arm you like, subject to some exceptions. And what is happening? The whole USA is struggling with this meanness of arm. Lot of people are killed because of these arm shooting. Our framers of the constitution learned this. People said, no, we are not going to give them. And therefore they placed restriction. Because there is no restriction, pornography is permissible in USA as a part of fundamental rights, subject to child pornography. There is no censor board at all in USA. No censor board at all. In Article 19, they placed restriction like morality. Why? Because the value system in India is different. But Mahatma Gandhi has also said, Ambedkar also said, our value system is entirely different. We will take good things, but we will not take bad things. And therefore, he made a comparative study. The Constitution of India is the beautiful illustration of the comparative study of research work. And therefore, he has included some of the good things, but did not include a lot of bad things which USA has faced and which other countries have faced. So when we take this, let us be very careful what are the do's and don'ts. I was just referring you one example of where the Supreme Court has imported with blind eyes the doctrine of freedom of speech and expression in India from USA, and the name of the case is Arup Bhuiya versus State of Assam 2011. There are indeed three cases: Ranif versus State of Kerala 2011, Arup Bhuiya versus State of Assam 2011, and Indra Das versus State of Assam 2011. In these three cases, one of the great judge of Indian Supreme Court, Justice Karju, Markandeya Karju, he has discussed the USA Constitution beautifully, but incorporated the USA jurisprudence in India without taking care which model we are following. He has committed great blunder, and he declared that membership of a terrorist organization, if you deliberately become member of a terrorist organization, deliberately, underline the word, consciously, deliberately become member of a terrorist organization, Karju says it is a fundamental right, because it's a passive member, and you will be punished only if you do something. Law says no. Once you consciously become, not innocently, if you deliberately, intentionally become member of a terrorist organization or unlawful organization, itself is punishable. In 2015, the government was worried. The government has filed a review petition, and review petition was accepted, because the same argument was given that USA doctrine is being taken here without taking note of what Indian situation is. So in 2018-19, I started writing an article that was published in Cambridge University Press on this Arup Bhuiya. Fortunately, it was published, and the similar line, same line on length, was taken by the Supreme Court in 2023 in Arup Bhuiya judgment. In 2023, the review case says 2011 judgment was a completely wrong judgment. So this is, I am just suggesting that when you do comparative research, we should be extremely careful. We should not be carried away by just because something is coming from West. Everything that glitters is not gold. Let us be very careful. If there are questions, the questions are welcome. Otherwise, I will move to the next significant part. Any question, any point you want to raise? We still have around 25 minutes to discuss. Otherwise, I move to Article 1. But before Article 1, if you have any question, yes, please. Anyone has any question, any agreement? And I told you what is most important? The disagreement that I love most. Okay, you keep in mind. Please write down. You can write down on the chat box also. Now let us discuss Article 1 of the Constitution. And I told you the Constitution is a beautiful model of comparative research method for every researcher, what to take and what not to take. We all know Article 1 is India, that is Bharat, shall be union of states. India word is used, Bharat is used, any word can be used. We are using India, the government is telling we can use Bharat. I don't think there is an objection in this. It is the government privilege, it is representative of the government. If the representative feel that Bharat should be used, Bharat can be used. What is the problem in this? India, that is Bharat, shall be union of states. Underline the word union. We all know India is a federal country. We can say quasi-federal, we can say unifederal. My teacher in BHU, Professor Shishul Kumar Verma, has coined the word unifederal in my dissertation work. So any word we can use. The point is, when India is a federal country where there is a distribution of power, why do not we use the word federation of states? And the students of constitutional law must be knowing it, that when the first draft of the constitution was made, the proposal was India shall be a federation of states. This was the proposal. Because India is a distribution of power. There are schedules and there are states. States are also powerful in their own arena. They have powers to make laws on certain list. Currently it is list 2, that is state list. So why not declare it a federation? This question was raised in the Constituent Assembly debate. That a federal country means it should be expressly provided. Is India a unitary state? No, then why union of states? Because union of states shows it is a unitary state. Dr. Ambedkar has answered this. And you can see why we have taken union of state, not federation of state, with the help of comparative legal research. That some critics have taken objection to the description of India in Article 1 of the draft constitution as a union of states. It is said that the correct phraseology should be federation of states. It is true that South Africa, which is a unitary state, is described as a union. So the argument was, dear friends, that South Africa is a unitary state. They have declared union of states. Why you are declaring India as a union of states if it is federal? He answers that no, words are different. Number one, that one word union of state is used in South Africa, that is called, but at the same time Canada is a federation, but it is also called union. Therefore he says, thus the description of India as a union, though its constitution federal, does not violate a usage. This is the first reason he gives. So use of word does not matter too much. But then he says, what is the real reason? And he says, but what is important is that the use of word union is deliberate. ऐसा नहीं है बाई चांस हमने ऐसे यूज कर लिया, छोड़ो यार कुछ भी वर्ड यूज कर लो. नो, Dr. Ambedkar says we have used it deliberately. Why? I do not know why the word union was used in the Canadian Constitution, but I can tell you why the drafting committee has used it. The drafting committee wanted to make it clear that though India was to be a federation, the federation was not the result of agreement by the states to join a federation. He said that I want to give a correct, clear message. It is not a contract. You are not a contractual party. ये कोई एग्रीमेंट नहीं हो रहा है आपके बीच में. सब आप आए हैं, आप मर्ज कर जा रहे हैं. That federation not being the result of agreement, no state has right to cede from it. 1947-48, Dr. Ambedkar has said, no state, once you come to India, no state has right to cede. Federation is a union because it is indestructible. You cannot destruct it. He was very well aware that in USA there was demand, and he has mentioned it. He has mentioned it. Though the country and the people may be divided into different states for convenience of administration, the country is one integral whole. Its people, a single people living under a single imperium derived from a single source. And what is the single source? The Constitution of India. The Americans had to wage, this is very important. The Americans had to wage a civil war to establish that states have no right of secession. And their federation was indestructible. The drafting committee thought that it was better to make it clear at the outset rather than to leave it to the speculation or to dispute. He says the real reason was we want to make India united, integrated. No one, once you come to India, no one has any right to see it. This he declared. He said that therefore we are not using the word federation, we are doing the word union. Why? Because the word of federation sometimes gives an impression that okay, this is a type of agreement and you have a right to see it. You don't have a right to see it once you join. So be very careful. So you have joined. Once you join, keep this in mind and see how great he was. In India there was demand of Azad Kashmir, demand of Khalistan. He made it very clear. No, India is indestructible. Anyone who demands this Khalistan, supports demand, have sympathy with demand, he is going against Dr. Ambedkar's vision. Anyone who says that Kashmir or Azad Kashmir type thing, he goes against the wisdom of Dr. Ambedkar, spirit of the Constitution, spirit of Article 1. So even if some states have been given some power, that does not make it sovereign. The Supreme Court said in the recent judgment of the Article 370, says it is asymmetric, some more power. So maybe Jammu Kashmir has more power, Himachal Pradesh, other states have less power. So this was the comparative study he has made. He used the word Africa, Canada and USA. While discussing Article 1, he used 3 countries. This is how he made the comparative study. Lastly, the thing which is very close to my heart. We all know sedition law, section 124 capital A of IPC, which is still existing, or section 152 of Bharatiya Nyaya Sanhita 2023. Now, sedition law is still existing in the name of sedition. The new law, that is Bharatiya Nyaya Sanhita 2023, has removed the word sedition, but the spirit is there. The spirit is there. That is still a speech crime. Of course, it has been little restricted. Now, should we repeal sedition law? This was the debate. And one of the arguments taken was from the comparative jurisdiction. There are various arguments why should we repeal, and there are arguments why should we retain. In our book on the law of sedition and freedom of expression and law of sedition in India, which Nivedita was referring to, which has been recognized by the Law Commission of India, and if you go to 279th report of the Law Commission 2023, download it, you will find the reference of this book not at 1, 2, 3, 4, 5, 6, 7 times, but more than 10 times. So Law Commission has made us proud that ILI work has been profoundly recognized in 2023. They accepted many of our recommendations. Of course, they did not accept some of our recommendations, like we suggested that mens rea should be included in section 124A. They did not accept it, but ultimately the Parliament has accepted it. So we can say that our recommendations were partially accepted by the Law Commission, partially accepted by the Parliament, but of course not all part has been accepted. Now, one of the arguments from comparative jurisdiction is that UK has removed a repealed law, sedition law in 2009. Why should we keep it? And so the New Zealand has also repealed it. So we should repeal because UK was the colonial master. It has repealed. We should also repeal it. Yep, they made IPC. Now they have repealed. We should also repeal. This argument looks very attractive. Very attractive. But then, as I told you, a researcher should not be carried away. That is the lesson for today. They have to go into the facts. They have to dig deeper and deeper. The way I have made a comparison between Hemant Soren case and Arnav Goswami case. The way I have made difference between USA Constitution, fundamental rights, especially free speech, and Indian free speech. A researcher has to dig deeper and deeper, and if he reaches to the conclusion that comparative law is applicable, we should proudly say, strongly say, yes, it is applicable, we should accept it. So it is a fact that UK has removed the law in 2009. There is no doubt. Sedition law was removed. But when we make comparison, we have to make comparison looking into the geography and the population. UK is lesser than Uttar Pradesh. We have 28 states. Is UK a good example? Somebody is speaking something. So this is first significant point that we need to consider. What is the area that UK has to take care of for the purpose of its territorial integrity? Small area, very small area. and then you go to the population. Can anyone tell me what is the population of UK, likely population, without googling? What is the population of UK? Reasonably, 3
Around
crores.
65 to 70 million people.
Yeah, in crores it comes around 8 crores. 7 crore, 8 crore. You add you add Delhi and Bombay and it becomes 8 crore. Just two metropolitan city. I'm not talking about Kolkata and Chennai and Bangalore. So the UK population, which state? Less than UP, less than Bihar. So in UP there would be 3 UK. In UP only. I'm not talking. 8 crore, you are comparing 8 crore population with 140 crore population. I'm not telling it cannot be compared. Please compare, but keep in mind whether it is comparable or not comparable. So, these are two things. What is the third important point? How many Prime Minister UK has lost? We lost 2 Prime Minister. What for? For secession. The Sri Lankan Tamil secessionist killed one of our beloved Prime Minister, Rajiv Gandhi. And the Khalistani terrorist killed another beloved and great Prime Minister, Srimati Indira Gandhi. How many Prime Minister UK lost? I'm not talking about how many Chief Minister, how many IS officer, how many IPS officer, how many governor, how many judges. They all were killed in India by these secessionist and separatist people. I'm not talking how many common person has been killed, how many children, how many women. I'm not talking about how many soldiers in uniform we have lost. Around 70,000 in last 70 years. How you are making comparison with UK? This is the third important point. Now let us come to other legal point. You would be surprised to know that the Law Commission of UK has suggested repeal of sedition law way back in 1977. They did not repeal in 1977, 1987, 1997. They repealed in 2009. You know the reason why? The Law Commission recommended you repeal it. They did not repeal for around 30-40 years. Why? It was not, dear friend, it was not a miss. It was deliberate. Why? Because of the threat of Irish Republican Army. Irish Republican Army was a threat to the territorial integrity of UK, and they said till the Irish Republican Army threat does not go away, the sedition will continue. And Irish Republican Army made a ceasefire in 1994. They did not repeal it. See, in 2005, when the Irish Republican Army declared that now no armed rebellion, you will have no arm, they have made a declaration. Then in 2009, they repealed it. But the researchers do not go in these deep facts. And that is one such reason. While on sedition, a lot of work is already there in the public domain in last 70 years. When we started writing, we were little worried. As a researcher, can we do it? And when we dig deeper and deeper, we found, we means I and Professor Manoj Kumar Sinha, who was the former director and currently Vice Chancellor of Jabalpur National Law University, we found that okay, these are the reasons that people do not know reasons. Why the researchers are not digging deeper? So there are many other reasons. Like Law Commission of India has never recommended repeal. Unlike UK, they have repealed. So we can take things from UK, but be very careful. Are we comparing with apple and orange? So finally, to conclude, which I have already discussed with you, dear friends, that is comparative study essential? I must say it is ought. We must do it. We must do it. If there is no comparative study, we are probably lacking in something. For me, we are lacking. Do something. But, a big but, not my but Mahatma Gandhi's but. Don't be carried away. Just because, oh my God, it is USA, UK has done, New Zealand has done, Australia has done, Canada has done, they are developed country, Germany has done, France has done. Don't be carried away. Remember Mahatma Gandhi said that the winds should come, but they should not challenge our fate, our values. Inquire facts. So what to do? Inquire facts and law. Go deeper and deeper. Why they have done. Why? Because researchers in India, unfortunately, don't go deeper and deeper, either because they don't have time or because they come with certain agenda. They want to show themselves a liberal like USA. They forgot what Dr. Ambedkar has said. We are not a type of USA model. Let me tell you a case of the Supreme Court. 1960, Babulal Parakh clearly said that the USA doctrine of free speech, clear and present danger test is not applicable in India. You want new citation? Take example of Jammu Kashmir internet shutdown case. What is the name? I'm just forgetting. Internet shutdown case. Supreme Court said in 2019 that the Western doctrine, that USA doctrine, is not applicable in India. So inquire facts and laws and draw your rational inferences. And rational inferences with new findings. Challenge the already established finding. If you can challenge the already established finding, that will be new finding. Anuradha Bhasin, thank you very much, Shivani. Thank you, Shivani. Good work. So, Anuradha Bhasin case. Anuradha Bhasin says that clear and present danger test of USA doctrine is not applicable to India. There are many cases. I'm not citing other cases. 1960 onward to 2019. But some of our researchers, some of our very, very, very big experts, they are very much obsessed and passionate for the USA doctrine. They always say liberty, liberal values of USA. We have to be very careful. Find new findings, get new findings, and challenge the popular narrative. Popular narrative. Your work will be published, your work will be cited, your work will be acknowledged, your work will be a type of work which people will remember for a longer time. So this is how the comparative legal research can be done within jurisdiction and beyond jurisdiction. I can keep on speaking for maybe 2, 3, 4 sessions on this comparative jurisdiction itself. I would love to do it, but time constraints are there. 5 more minutes are there, but I am available. If there are other questions, they are always welcome. Thank you very much. Thank you, NLU Goa, for finding me to interact with these young brains. They have also interacted with me and not disappointed me. I'm very, very, very happy to know this new brain which is there in NLU Goa. I think the Goa, with the help of these new researchers, is going to rise and rise. Convey my regards to Honorable Vice Chancellor Sir, Honorable members of the Par Council and other faculty members. Thank you again, Nivedita.
Thank you very much, sir.
Questions
Very
are still
wonderful
welcome.
lecture, sir.
Ankita has raised one question. Yes, Ankita, please.
सर आई वांट टू आस्क, जैसे कि न्यूली इमर्जिंग लॉज आ रहे हैं, स्पोर्ट्स लॉ है, स्पेस लॉ है, एआई का इंटरेक्शन है, तो सर हम कैसे, मतलब कौन सी कंट्री को कैसे वाइजली चूज करेंगे कंपैरेटिव स्टडी के लिए?
Yes. So therefore I said that when you choose a country there has to be a reason. So अगर आप स्पोर्ट्स लॉ लेते हैं तो आपको ये बताना पड़ेगा कि जो स्पोर्ट्स लॉ है वो कहाँ है, और उसके बाद आप उन कंट्री को चुन सकते हैं और बता सकते हैं कि यस, चूंकि स्पोर्ट्स लॉ यहाँ है, therefore because sports law is in these places, therefore I have taken this. If sports law are there in many countries,
पहला विषय है जो देश में जो लोकतंत्र
जो अगर कई जगह है तो आप कह सकते हैं कि आउट ऑफ दीज 4-5 कंट्रीज आई हैव चूजन 2-3 कंट्रीज बिकॉज दे आर वेरी कॉम्प्रिहेंसिव. So this is how you can say. Fine.
Okay, sir. Thank you.
कोई और क्वेश्चन है आपका?
Yes, sir.
हाँ
Do
बताइए.
we have any more questions? Yes, Mr. Deol Patil, please go ahead.
Sir, just wanted to understand, assuming we are not working exclusively in the comparative law domain of our research, what percentage of the thesis or what percentage of the research that we undertake is usually recommended to be a comparative study so that it becomes a wholesome study?
There is nothing like percentage. Nothing like percentage. That depends on whether the topic of title of PhD is a title which is peculiar to India or it is something which is more conceptual in nature. It is more conceptual in nature, then a comparative study, maybe one chapter I think would suffice. If it is not very conceptual in nature, then in those cases you can make a comparison of laws when you discuss India, but there should be some head, not just in text, some head comparison with USA, Australia, so it will show that you are also aware, means you are not making any recommendation without knowing what is the trend in globe. So I would suggest that generally one chapter, but in case one chapter is not possible, at least some heads should be there to show that yes, some comparative study has been done. Of course, there would be a situation when no comparative study is required. Take example of empirical studies. So in empirical study, probably comparative study of jurisdiction may not be required, but then intra-jurisdiction, within jurisdiction it may be required. So you take various samples, you compare with samples, that is also a small type of comparative study. You have, Patalji, if you have any other supplementary?
No, sir. Thank you.
Ankita, you have any supplementary? Shivani, please.
Yeah, good evening, sir. Sir, I want to ask, like, if India needs law like sedition to suppress the secessionist feelings of its people, then why the Supreme Court has put an abeyance this law? The Supreme Court has put this law in abeyance.
Yes, very good question. Number one, this question is not on the current topic. Please take note. But I'm answering.
Just because you discussed.
That is good. The point is that number one, the sedition is a law which is grossly abused law. The law, to me, the law itself is not problematic. It is not the section which is problematic, it is the action which is problematic. On the drop of a hat, sedition FIR is registered, and then we are bloodthirsty sometime that the person must be arrested because he has made some statement against India. And we are very sensitive to small statements and we immediately rush to the conclusion, this is the anti-India statement. This is not India. India is not so weak that just because of one statement, the Indian territory, Indian integrity will come to trouble. But sometimes some of our politicians, which is in every party, no state is immune. Sedition is abused in Kerala, sedition is abused in Karnataka, it is used in Maharashtra, it is used in UP. So it is not that it is only abused by one party or other party. So this is one reason that the Supreme Court found that the abuse is remain unchecked, and the governments are not taking any clues that the abuse should be stopped. They could have sent advisory to the maybe police officers not to abuse it, but they have not even taken care of that. This was one reason. Second is if you read the judgment, order, sorry, not judge, order, there is no stay on 124 capital A. This again is a misnomer. And for this purpose, you can read one of my case comment in newsletter when the order was given stay. In that month, newsletter of ILI is published. I've read the order, and they say that no proceeding will go, but they do not say that no fresh FIR can be registered. Fresh FIR can be registered. So it is not that it is completely stopped. This is a misnomer. Of course, the proceeding has to be stopped, and that way bail is being granted. But the problem is that if you stop sedition law, now the people would be booked under UAP. So you want to secure something, but in the good faith in securing something, you are bringing a far more draconian law for misuse. And once, in case of sedition law, the bail provisions of CRPC will be applicable, but in UAPA, the bail provisions of UAPA will be applicable. It will make bail far more drastic and difficult. Supreme Court probably did not take note of this, that it may be abused. Now UAPA provisions can be abused. Third point is that is abuse a ground to stay? If it is so, next day are you going to stop the provision of 498 capital A? So that is the difficulty with the Supreme Court order. But anyway, the order is there. So this is how I want to answer it. Yes, any other question is welcome.
Thank you, sir.
Sure.
Sir, you had mentioned about mens rea and its utility in the sedition law. How can one absolve the aspect of mens rea from the sedition aspect itself?
See, again I would say that this is not a question on the comparative law, so it is better we concentrate on comparative law. That is good. I have a session on 15. So if there are no question on comparative law, I will answer it. Otherwise, I will reserve it for 15. The small point is that currently the sedition law under 124A do not use the word of mens rea. And this gives an impression that it is strict liability offence, but it is not a strict liability offence. And therefore, we have suggested in our recommendation that mens rea word should be expressly included, which the Law Commission did not agree with my consultation when there was consultation with me and the Law Commission members. But fortunately, the word purposely and knowingly word is used in the current section 152 of Bharatiya Nyaya Sanhita. So that is how I try to address this, Binod. But I will try to address this in the next 15th lecture, elaborate, and you can also elaborately discuss that question.
Thank you, sir.
In any other question on comparative aspect, how to do, what to do, any confusion because of my lecture, anything which remain unanswered, anything that you disagree.
Sir, I think there is one question.
Wasim Raja's question. Sir, the Wasim Raja question is, thank you Wasim. Sir, this comparative analysis needs higher attention while doing the research in this context. How we can better understand and cope up with the challenges coming in way of comparative research? Very good question. Certainly it needs more attention. The whole point is that whenever an argument is made, go to the primary sources. Do not just rely on readings. Readings are very good. So somebody says that in USA, in some judgment, this was the case. Try to read that judgment, because there is a possibility, not possibility, indeed the same mistake, this mistake was done by Justice Karjo. He has taken what he has done, he has taken minority opinion of some of the judgment and made it a part of majority opinion in India, without going through how minority opinion is a better opinion for India. So do read the original work. So if you read the original judgment, if you read the original law, then probably you will be in a better position that how to appreciate the comparative law. That I'd say that do read the original law, original judgment, and the critic of those judgments or those laws. Any other query, please?
Do we have any more questions?
निवेदिता जी, हमें लग रहा है शाम का समय है, लोग थोड़ा चाय वाय भी पीना चाहते हैं और क्या टहलना भी चाहते हैं बाहर. मुझे नहीं पता मतलब कहाँ कहाँ से लोग हैं, लेकिन थोड़ा मौसम भी अच्छा है तो इसलिए अब उनको जाने दिया जाए. ठीक है, कोई क्वेश्चन नहीं है. हाँ,
So we'll take it forward on 15th.
यस, ठीक है, बहुत अच्छा रहेगा. सो आई वुड रिक्वेस्ट इफ़ यू वांट to maybe come in my regular touch, you can go to my channel, you can find various lectures. These lectures are especially given for researchers. Take it. There would be around 40 lectures. Most of these lectures are given for the researchers, for the law teachers. You can find some of them may be useful to you. Thank you again.
So thank you so much, sir, for the session. We'll meet again on 15th, and thank you to all the scholars who were here with us. Thank you so much.
I am signing out now.
Yes, sir. Thank you, sir.